On the 29th of December, South Africa instituted proceedings before the International Court of Justice against Israel for genocide in relation to the ongoing war in Gaza, and it requested that the court adopt provisional measures. While South Africa is in no way directly involved, the Genocide Convention's 9th article allows any state party to the convention to bring a case against another, regardless of a direct link to the conflict in question. This was considered and affirmed by the court in its judgment in Gambia versus Myanmar. The rationale underlying this is that the convention creates an obligation on contracting states to all other parties to the convention, known as the erga omnes doctrine. In substance, the main difficulty that South Africa will face is proving genocidal intent. However, here Israel's downfall may be the many shocking statements from Israeli officials which we've seen all over social media over the last weeks and months. For example, Israeli Army Major General Hassan Alian's statement that Palestinians were human animals and must be treated as such, and that there will be no electricity and no water in Gaza, there will only be destruction. Proceedings before the International Court of Justice can take many years, and often by the time a judgment is reached, it is too late for the victims, who have died and been buried. To this end, South Africa has requested that the court adopt provisional measures. There are several parts to the assessment of whether provisional measures should be ordered. The court must ascertain whether it appears that the acts complained of by the applicant are capable of falling within the scope of that convention, ratione materiae, as was said in Azerbaijan versus Armenia. Similarly, the court must be satisfied that the rights asserted by the party requesting such measures are at least plausible, as was said in Belgium versus Senegal. There must also be a link between the measures requested and the plausible rights that are being violated. There are separate proceedings ongoing before the International Criminal Court in relation to Israeli war crimes and crimes against humanity. However, these proceedings are against individuals, as this is all the remit of the International Criminal Court allows. The International Court of Justice, on the other hand, is the proper arena for interstate applications such as this one. Oral submissions for South Africa were heard today at the Peace Palace in The Hague. Israel's oral submissions will commence tomorrow, the 12th of January, at 10 o'clock European Central Time.